Question number 91. I heard that I could be forced to file a Chapter 11 instead of a Chapter 13. Why would that be? Well, if you fail the means test and you think you'll be required to file a Chapter 13, you need to look at the total amount of your debts. At the moment, if you owe $336,000 in unsecured debt, that's like credit card debt, or $1.2 million in secured debt, like a mortgage on your home, you're not eligible for Chapter 13. Those numbers change periodically, so you have to check the status of that. But if you're in that position where your debts are in excess of those numbers, you do not qualify for Chapter 13, and you would probably have to file a Chapter 11 bankruptcy. And if you did, you really would need legal help with that. Question number 92. If I pass the means test, does that guarantee that I qualify for Chapter 7? Well, it's not a complete guarantee. It is possible that the U.S. Trustee, upon review of your file, could find what they call general abuse. General abuse is a result of the U.S. Trustee looking at your filing and, after reviewing all of the circumstances of your case, taking the position that letting you discharge your debts under Chapter 7 would be an abuse of the bankruptcy laws. Question 93. Well, what would happen then if the trustee took that position? You could challenge the position of the U.S. Trustee and let a bankruptcy judge decide. If the court were to find abuse, then you would face either a conversion of your filing to a Chapter 13 or a dismissal of your bankruptcy filing. Question 94. Well, if that happened, how could I challenge the U.S. Trustee? Under the law, we all know that there's something called the burden of proof. There's a big distinction between presumptive abuse and general abuse when it comes to the burden of proof. If you fail the means test, you are presumed to have filed an abuse of bankruptcy if you file a Chapter 7. And then the burden of proof is on you to establish that you're not abusing the system and that you're actually entitled to use Chapter 7 to discharge your debts. The burden is on you. You must bring forward evidence of your right to use Chapter 7. It's different, though, with a claim of general abuse. So with a claim against you of general abuse, the opposite is true. The party claiming you're abusing the system, usually the U.S. Trustee, has the burden of proof to establish that you are not entitled to Chapter 7 protection. So it's much harder for the U.S. Trustee to prove in a general abuse situation that you're not entitled to Chapter 7. Question 95. How often can I file for bankruptcy? Well, under Chapter 7, you can file every 8 years from a previous Chapter 7 filing, or 6 years from a prior Chapter 13 filing. For a Chapter 13, that can be filed 4 years from a prior Chapter 7, or 2 years from prior Chapter 13 filing. Question number 96. Will I lose my retirement accounts or payments from Social Security? The answer to that generally is no. Retirement accounts that are ERISA qualified aren't considered property of an estate and aren't taken into consideration as assets. That would be your typical 401k or IRA. Social Security benefits are protected from assignment or garnishment for debts in bankruptcy. Once paid, the benefits continue to be protected only as long as they can be identified as Social Security benefits. For example, money in a bank account where the only deposits into the account are direct deposits of Social Security benefits are identifiable, are generally protected. So what happens is if you mix that money with other funds, then it's possible that they could be garnished and could be taken. So if they're segregated into a separate account, they cannot be taken. Question 97. How long does a bankruptcy stay on my record? Well, bankruptcies remain on credit reports anywhere from 7 up to 10 years. Question number 98. Can I do anything to remove a bankruptcy from my credit report? Well, while you can't do anything to remove it from your credit report, you can file an explanation with the credit reporting agencies, briefly describing the events resulting in your bankruptcy. If an account is reported inaccurately, you can request the record be updated to reflect the actual situation. I would advise you to do that. Question number 99. Can a creditor continue to contact me after I have filed for bankruptcy? Well, once again, contacting you is a violation of the automatic stay provisions of the bankruptcy law. Once you file your bankruptcy petition, be sure to write down the case number that has been issued to you by the clerk when your case was filed. And keep that number by your telephone or in your pocket if you're getting calls on your cell phone. When a bill collector calls, tell them that you've filed for bankruptcy and give them the case number in the court. For example, United States Bankruptcy Court, Southern District of Florida. If the same collector calls after you do that, then you should contact your attorney if you have one, or if you're filing yourself, you should contact the Better Business Bureau and your state's Attorney General's office. You should also inform your trustee. Question number 100. Who will tell my creditors that I have filed for bankruptcy? Well, the bankruptcy court notifies by mail all creditors, advising them that you have filed for bankruptcy. It gives them your case number, tells them about the automatic stay, gives the name of the trustee assigned to your case, sets the date for the meeting of creditors, tells them the deadline set for filing objections to the dismissal of debts, and informs them where they can file their claims. Question number 101. What is a reaffirmation agreement? If you own secured property, for example, a car loan or a mortgage, then you have to tell the court what your intention is with regard to that property. You do this by filing something called a statement of intention, and it's part of your schedules in your bankruptcy filing. The form tells the court if you want to give the property back and get rid of the debt, which is called surrendering the property, or you could decide to keep the property and agree to pay the terms of the existing contract, and that is called reaffirming the debt. In the case of an automobile, they would typically want you to file and sign a reaffirmation agreement. In the case of real estate, that is not necessary. That's the 101 questions that we see all the time. I hope this